everyone, I am Sharana Suha binti Khairil Amri.
Hi guys, I am Nurul Ainadirah binti Muhammad Razi.
Hi, I'm Nur Izzati. The Constitution of Success Berhad, the company, contains among others the following provisions. Article 41. A lessor of the premises of company has the right to appoint a director to the board of directors of the company. Article 44. Any dispute between the company and its members should be referred to arbitration. A dispute arose the company and Cik Wisni, a member of the company. The company brought the matter to court for settlement. Cik Wisni, however, is dissatisfied with the action of the company and seeks to stay there. Ben to you Ben, which is the company's lessor, intends to enforce Article 41 and nominates one of its branch executive, Mr. Wafi, as the Director of Success Berhad. The Director of Success Berhad disagreed with the appointment and wished to challenge its validity. By applying the relevant principle of law, advise the parties of their chance of success.
Next, we will be moving on to our explanation about all the questions given. The first issue is whether the effect of the contract is binding between Cik Wisni and the company. As the Constitution is considered being a binding contract between the company and members about the right of membership, both company and members are bound in all their acts to follow or observe all the provision in the document. The other party may take action to enforce it in the event of a party infringing any of the provisions. This allows them to sue and be sued for breach any of the legal provision. According to Section 32, Subsection 3, subject to the provision of this Act, the Constitution adopted under Subsection 1 shall be binding on the company, its members, and its directors. This can be illustrated in the case of Hickman and Ken. In this case, the article of association of the defendant company stated whatever conflict existed between itself and its members could be referred to the arbitration. And then, there was a disagreement between the company and one member. Hickman brought the matter to the tribunal. The company claimed on an arbitration clause ground to stop the case. The court held that the article represented a contract between the company and its members. The arbitration clause was a binding arbitration agreement and the parties were obligated to refer the dispute to arbitration. As a shareholder, Hickman was required to adhere to the company's arbitration procedure and was unable to appeal to trial.
Thank you, Ain, for the explanation. Applying to this situation, Cik Wisni, who is the member of the company, dissatisfied with the action of the company to bring the matter to the court and seeks to stay the action. While there is provision of the company which any dispute between the company and the member shall be referred to arbitration. In this scenario, we can see clearly that the company succeed in implementing the provision against the member in the memorandum MOA and association AOA. Not all regulation or article in the company memorandum may have contractual effect. The company also allowed to enforce the personal right that contained in AOA against the member. If the company violate the AOA and MOA rule that does not grant members personal right, then the operation may fail. In the conclusion, there was a binding contract between the company and Cik Wisni because the provision for arbitration was a binding agreement and obliged the parties to refer the matter to arbitration. For the second issue, Izzati will explain to
The
you.
next issue is whether there is a binding contract between the Constitution of Success Sdn and Bank to You Bank. By the virtue of Section 32, Subsection 3 state that, subject to the provision of this Act, the Constitution adopted under Subsection 1 shall be binding on the company, its director and its members. Other than that, by the virtue of Section 33, Subsection 1, the Constitution shall, when adopted, bind the company and the members to the same extent as if the Constitution had been signed and sealed by each member and contain government on the part of each members to observe all the provisions of the Constitution. This can be illustrated in the case of Raffles Hotel Ltd v Malayan Banking Berhad. According to the case, Malayan Banking Berhad MBB was the lessor of the property Raffles Hotel is located on. The company was a land lease. In the company's article, it was provided that the lessor should have the power to appoint a company director. Based on the power conferred on the post, MBB appointed itself as the company's director. The business objected and requested a resolution invalidating this nomination. The problem before the court was whether MBB would invoke the article to nominate itself as the company's director. The Federal Court and the High Court held that the articles could not be a contract between a company and a non-member. Since MBB was not a member of the company, no enforceable right was bestowed on it by the articles to name a company director. The appointment was thus void and has no legal effect. Come here and please explain the application of the law.
Applying to this situation, Bank to You Banks, which is company's lessor and intend to Article 41 and nominates one its branch executive, Mr. Wafi, as a director of Success Sdn Berhad. The director of Success Sdn Berhad disagree with the appointment and wish to challenge its validity. In this situation, Article 41 did not give any enforceable right to Bank to You to appoint the director, since Bank to You is not a member of the company. Article 41 could not form a contract between the company and a non-member. In conclusion, the appointment of Mr. Wafi as the director of Success Sdn Berhad was void and no legal effect. Okay, that's all from us. Thank you. Bye-bye.